The most litigated provision of the United States Constitution is the 14th Amendment. More cases spring from it, more arguments derive from it, more controversies associated with it. And most of the attention is to the second sentence in Section 1. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. As an illustration, in first-year constitutional law, we devote 56 sessions to try to explain the Constitution. Almost two-thirds of that is devoted to looking at phrases, due process of the law, and equal protection of the laws. So the 14th Amendment is probably the candidate most likely to be the vehicle for Mr. Lincoln's new birth of freedom. But the 14th Amendment had broader meanings and purposes, and that's the point I'm trying to make today. Point number one, it reversed the Dred Scott decision, the infamous 1857 ruling that African Americans were not citizens and could never be citizens. The 14th Amendment said they were citizens. The second basic objective is the one that's most controversial. For the 14th Amendment begins to define liberty, begins to define the rights of citizenship. It begins to define the meaning of equality. The words have been used in American history, but mostly in political argument. The Constitution itself said surprisingly little about a general theory and definition of liberty, and it said nothing at all about equality. In Ken Burns' award-winning documentary, The Civil War, at the beginning of his discussion of the events of 1863, Mr. Burns made an interesting observation. Quote, "More than once during the Civil War, newspapers reported a strange phenomenon. From only a few miles away, a battle sometimes made no sound, despite the flash and the smoke of cannon. These eerie silences were called acoustic shadows." Now, this phenomenon of acoustic shadows, along with the gaps and the silences of the text of the Constitution, are important because that's what the Supreme Court does. It interprets the sounds of silence. It interprets the ambiguities and the broad, open-ended phrases. And when it looks back at history, it can see evidence of sound and fury and controversy, but it can't hear anything or delineate anything specific enough to give a legal solution to a problem. These acoustic shadows become a metaphor, even today, when issues come before the Supreme Court. The story of the 14th Amendment begins with the inadequacy of the 13th Amendment. When Congress proposed and the states ratified the 13th Amendment, it put an end to an institution created by state slave codes, but it created no definition of citizenship, and it created no definition of the rights that are associated with citizenship. And the South took advantage. Southerners, still hurting, suffering, angry over defeat, responded to Northern policies with defiance and protest. In the fall and winter of 1865, Southern conventions and legislatures responded to Northern programs with the rhetoric and the policy of resistance to change beyond abolition of slavery. The historian Charles Fairman tells us that in all the discussion in these conventions and legislatures of 1865, when the 13th Amendment is in the process of being ratified, there is virtually no suggestion that with freedom the Negro people would ever be able substantially to improve. In the view of the South and the antebellum leaders that were being restored to power, as if the Civil War hadn't happened, one status, slavery, had been destroyed. A new status must now be established for the freedmen. The status for the Negro was a matter to be settled by white man's government. The result was something known in history as the Black Codes. These are special statutes passed by Southern legislatures that did, in fact, create certain civil rights for black people. They could enter into contracts, for example. But these codes were distinguished more by the restoration and the preservation and the maintenance of policies of discrimination. They explicitly said black people could not testify against white people. For those of you who are members of the NRA, you can take note. Southerners said blacks did not have rights to carry firearms. That became an important issue in the 14th Amendment. There were special restrictions on renting and owning land. Black males were required to work and forbidden to leave work, which sounds just a little suspicious. If they did quit work before the expiration of their term of service, they forfeited all their wages for the entire year. A deserter would be charged for the costs of recapture, and the charges would be set off against future wages. For most Americans that had a degree of objectivity, this looked suspiciously like slavery all over again. The objective was to keep the Negro in his place, a phrase which was born at this time, to ensure that the planter and farmer would have a guaranteed cheap labor supply. Congress did respond to this, and Congress began to respond vigorously with civil rights legislation for essentially the next decade. The Civil Rights Act of 1866 passed. President Johnson, who has been recently labeled the worst president in history, although there are a few others that contend for that title, vetoed the legislation, and his veto was overridden by Congress. And the Civil Rights Act of 1866 is still one of the most powerful pieces of civil rights legislation on the federal books. The legislation said a number of specific things, and these specific things begin to give you a hint of what is the meaning of civil rights when the 14th Amendment is being considered, and what is the purpose of the 14th Amendment. They had the same right to enter into contracts and to enforce them. They had the same right to sue. They had the same right to be parties and to give evidence in court. They had the same right to inherit, purchase, lease, sell, hold, and convey property. They were entitled to the full and equal benefit of all laws and proceedings for the security of their person or property. And they were to be subject to like punishment, pains, and penalties, and to none other. In other words, no dual criminal codes. Now, the problem with this was twofold. One, as you might expect, opponents cried in horror. It was inevitable, they said, that this would lead to worse events. And of course, their catalog of worse events are things we now take for granted. The right to vote, an end to segregation, blacks on juries, and horror upon horrors, interracial marriage. Proponents cast these claims aside and said this just provides for a form of legal equality. The bill passed. And then Congress started thinking. And what they thought is, this is a wonderful piece of legislation, but do we really have power in the Constitution to pass it? And they did all their research, and they read Madison's notes, and they read John Marshall, and discovered, hey, there isn't anything in the Constitution which gives us the right to create these civil rights. we need some actual constitutional authorization for this law. And what they did is they passed the 14th Amendment. The primary purpose of the 14th Amendment was to provide after-the-fact ratification for what Congress had already done in the Civil Rights Act of 1866. Now, this history is very uncomfortable for men like Thurgood Marshall and Earl Warren and William Brennan, who wanted to see in the 14th Amendment a broader idealistic purpose. But the Supreme Court, oh so briefly, saw a broader purpose. The case, if you ever want to look at it, is a case decided in 1879. It's called Strauder versus West Virginia. A black man is convicted of crime, murder, and sentenced to die. He's convicted and sentenced by an all-white jury, indeed a jury in which a West Virginia statute has said no blacks can serve. So the question becomes is whether or not statutory exclusion of blacks from the pool of potential jury members violates the 14th Amendment. Now the Supreme Court's got a problem. They know the history. These men on the Supreme Court in 1879 lived through the 1868 debates of Congress and the 1868 debates. And they know that the proponents of the 14th Amendment said this wouldn't necessarily mean blacks would serve on juries, and it didn't necessarily mean blacks would vote. How were jurymen selected? They were selected from voter rolls. So this case was the first step carrying the concept of legal equality past the narrow civil rights created by the 1866 Civil Rights Act to a broader concept of racial equality. And the Supreme Court embraced that. They struck down the conviction. They said you couldn't execute the man. And they said a number of things that were mined decades later. The language was mined by Thurgood Marshall when he was litigating Brown versus Board of Education and a variety of civil rights cases in the 1940s and the 1950s. The 14th Amendment was framed and adopted to assure to the colored race the enjoyment of all civil rights enjoyed by white persons. The law in the states was to be the same for black and for white. The very fact that colored people are singled out and expressly denied by a statute to participate in the administration of law as jurors fixes upon them a brand of inferiority. These are concepts which become tools for lawyers in the next century. How can it be maintained that compelling a colored man to submit to a trial for his life by a jury drawn from a panel in which the state has expressly excluded every man of his race because of color alone, however well qualified, is not a denial of equal protection? What was the amendment's purpose? The Supreme Court in 1879 said something which kind of takes your breath away because it's modern language. It's modern legal reasoning. The amendment's aim was against discrimination because of race, color. Its design was to strike down all possible discriminations against those who belong to it. The tragedy is they didn't hold to this view through the rest of the century and the beginning of the next. The tragedy is that the United States Supreme Court turned its back on this idealism and for a time betrayed the 14th Amendment and its purpose. And it's that story I'll try to tell next time. Thank you.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.